Hi everyone, I'm Pedro Barros, the Channel Manager for Contractors at Remote. And we have Tara Vasdani with us, Managing Partner of Remote Law Canada. Tara, tell us a bit about what you do.
So, morning everyone. My name is Tara Vasdani. Thank you, Pedro, for that introduction. I am the managing partner of my law firm, Remote Law Canada, and we focus exclusively on employment law, civil litigation, and remote work issues for employers and employees.
This is a very opposite subject. What role does compliance and legal play in this new, increasingly global workforce?
Well, I mean, you're talking to a lawyer, so compliance is everything, right? I think that since the onset of the COVID-19 pandemic, it became ever more important. COVID really put us sort of in this environment where we were stuck between emergency remote work scenarios and these well thought out remote work scenarios. And so when you think about compliance, you're really thinking about how to take your environment and allow them to continue to operate remotely or in a hybrid fashion or a flexible distributed fashion for the long term. Whereas in COVID-19, it was really just about how we can do this temporarily, and compliance really wasn't at top of mind. And so when we're talking about compliance, I think some of the basics are ensuring that your employment agreements, contractor agreements, remote work policies, a lot of your regular policies, so sometimes that's privacy, confidentiality, intellectual property, a lot of those are reimagined in a way where they can apply to the remote work, hybrid, flexible, distributed scenario as much as they did in office. There has been quite a lot of movement since the pandemic specifically, but there was, of course, this explosion in the industry. It was just on a much smaller scale pre-COVID. And so I think that as the legislation and the regulations continue to respond to this new scenario, it will be easier for employers to be compliant. But in the interim, it's really, really important to connect with lawyers and to connect with policymakers to ensure that you are meeting a lot of those requirements when you're operating these teams so that you're not in certain dangerous scenarios such as termination, any breach of human rights that an employee may have if they're in a different jurisdiction and not knowing how to address that. And just quite frankly, lawsuits in different jurisdictions if you're operating remote or flexible teams where employees are elsewhere.
Awesome. So the world has changed in terms of global employment, and I think we'll continue seeing a significant evolution, especially, and you mentioned the regulatory framework. But what special considerations should employers be aware when hiring specifically contractors internationally?
So it's really important, I think, from the get-go to distinguish between what the contractor is and what the employee is. I think what a lot of employers get wrong is the fact that just stamping the agreement with the words independent contractor is not sufficient for the law to recognize that person as an independent contractor. You really have to meet what the certain factors are in that jurisdiction that identify between an independent contractor and an employee. So, for example, in Canada and many of the states in the US, the contractor will provide their own tools and equipment. The contractor will submit their own invoices. The contractor will often be able to work for several employers at one time. The contractor will set their hours of work and the contractor will set their own work location. What tends to happen is that employers tend to hire these individuals and set their work location, set their hours of work, provide them with the tools and equipment. And when that becomes critical is when there is some sort of breach of that arrangement, because all of a sudden you're in a situation where that employee may be wanting to claim, that contractor may be wanting to claim that they are an employee. And then you're on the hook for back pay of taxes, you're on the hook for benefits that should have been offered, and most importantly, you're on the hook for severance or termination pay. And so when you're thinking about hiring someone as a contractor, as great as sometimes those employers of record may be, you really have to ensure that a lot of those factors of what the court would consider a contractor embodying are met when you're hiring that contractor in that specific jurisdiction where they're working.
Very insightful. Yes, we see. No, it's true. the just because you have an agreement doesn't make you a contractor. I think it's a critical point here, and the specificity of each country's or each even state regulation should be very catered for. I'm sure your field of work has evolved massively over the last couple of years. What have been the most significant changes in your work since the remote work boom? And what's next for your work and for your field of operation?
So I think, just speaking for lawyers and law firms in general, there has been a huge shift, like the rest of the world, towards remote, flexible, hybrid, distributed teams. But in terms of the actual way that lawyers operate, for example, employment lawyers, you have all of a sudden had to address a lot of these lacunas in the legislation or the regulation to assist a lot of employers with meeting a lot of these compliance obligations, because many of the regulations and the legislation across the globe still don't recognize remote work as a workplace. They still don't recognize a remote worker as a employee under the law who is entitled to certain protections. And so it's been incredibly important to begin to address a lot of those lacunas. And I'll give you a perfect example. I'm actually working right now with a congressman in Washington State so that we can start to put together a bill that will address a lot of these sort of missing areas in legislation. And so that's probably been, I think, the most readily apparent is the fact that lawyers need to step in and sort of help to address a lot of this missing information because the legislation and the regulations just have not caught up.
Yeah, certainly. And it's even if they do, I think even for employers will be very hard given how tough these things are for you to understand. So clearly, good advisory is very welcome. And we many times see customers obviously with challenges and with questions. And what are the most common mistakes you are seeing companies making when they are hiring a global team of contractors?
The most common mistake I would say that I see employers make when they're hiring contractors or employees is not really setting out what the requirements and the boundaries of that relationship are. So, probably the most critical is the remote work policy. So one of the most commonplace mistakes was employers will hire contractors or employees that are operating remotely as a digital nomad in a flexible environment, but don't set out the parameters of that relationship. And so, for example, when you hire an employee or you hire a contractor and you wish that they will work from a certain location a certain number of days in the week, or all of a sudden they're not performing the way that you want them to perform from that location, and so you want them to return to, if they're a contractor or a digital nomad, to your jurisdiction, or if they're an employee, you want them to return to the office. They will often not set that out in the remote work policy. And so what ends up happening is that it's a constructive dismissal. If all of a sudden you've got this employee that you are permitting to work from home or from different jurisdictions, or you've got a contractor that you're permitting to work from different jurisdictions, you can't change the terms of that relationship once the relationship has already commenced. You could, but it's often too late. There's often been a breach, and that's when they want to change the agreement, and it's not retroactive. And so that's probably the biggest mistake that I see happening. And then really just in a general sense, it's the fact that they are not creating these comprehensive agreements to address this relationship. And so they're not sort of considering a lot of the privacy considerations or confidentiality requirements, things like that, until there is a breach. And then all of a sudden, you're sort of using this legislation that I've already said is missing a lot of the information that would apply to this arrangement. And so it's really just about getting down to the wire and coming up with a comprehensive agreement that addresses a lot of these common issues that could come up, instead of using some of these boilerplate or templated documents.
Definitely. Getting to obviously to the end of our quick conversation here, what advice or best practices can you give to employers? The 30,000 foot view of the world of employment. What's your top advice?
So I think that paperwork and compliance really is key. As I mentioned, as long as you're putting together a comprehensive agreement that lays out a lot of the requirements for that arrangement, you will be fine to operate long term. When you're dealing with contractors specifically, meeting a lot of those factors that a court in that jurisdiction would identify as a contractor is key. Because many of the time the issue comes from not having comprehensive agreements, as well as not addressing that relationship in the eyes of the court. So not understanding what the court would consider a contractor, and instead just sort of guessing.
Tara, thank you very much for your insights and sharing your experience around global employment and contractor hiring.
My pleasure. Thank you guys so much for having me.